Hey, it's John with Vision Advisors, and thank you for joining us for this very special estate planning conversation. This is part one of a two-part series where we're going to be having a conversation about how estate planning services can complement what you're currently doing in your financial services practice. And at the same time, it can also be a conversation starter to engage with prospects or to re-engage with clients to be able to discuss with them the opportunity to bring something to them, maybe that they haven't done, but also an opportunity to create the chance to sit down with your clients and evaluate areas in their financial planning maybe you've not had the opportunity to yet have the conversation with. I'm very excited to be able to have on the phone with me today Sierra Lister, and I'm going to introduce her in just a minute. But let me give you just a quick disclosure of what Vision's relationship is with integrated trust systems and the estate plan you're going to be learning about. This is a referral-based service that we're going to be bringing to you, the financial advisor community. We are not being compensated for this at Vision Advisors. You, as a financial advisor, are not going to be compensated. This is an opportunity for you to partner with an estate planning organization that does estate planning as good or better than anybody I've seen. I've been privileged to work with the founder of this organization, Gary Lofsgaard, for a number of years. Gary is a phenomenal guy. I've had an opportunity to meet their new chief counsel, and she is an amazing lady. Now, Vision Advisors doesn't give legal advice. We don't give tax advice. That's not who we are. We are an insurance marketing organization, but we're so excited to be able to bring this resource to you. Let me tell you a little bit about who we have on the call with us today, and let me introduce you to Sierra Lister. Yes, she's pretty, but she is a real lawyer, and she's pretty sharp. When you look at her credentials, you're going to be impressed. She's a graduate of the University of Florida. She got her JD from the Ave Maria School of Law, and she currently serves as the Chief Counsel of Integrated Trust Systems, and she also serves as a network attorney within this national network of estate planning attorneys that Integrated Trust Systems brings to the table. So we're going to do a little Q&A with Sierra this morning and have an opportunity to ask some important questions that you are probably asking and would like to get some answers to. And the first one of those questions, Sierra, I want to throw at you is really this. Why should a financial advisor consider adding estate planning services to his or her practice?
Well, hi, thanks for that nice introduction. I think that going through the experiences that advisors have had, the number one thing is not referring out your clients. You're going to help them with everything that they need, from their insurance to any sort of financial advisory services. And then you're going to also make sure that their estate planning gets done. So instead of sending them off to a lawyer that you might have a referral system with, you don't know what's happening, you don't have access to those documents, and you're not involved in the process. So this keeps that client relationship very close to you, and now you become a full resource for your clients to plan for their estate while they're alive and after they are dead.
Absolutely. And having been involved in estate planning myself for many, many years when I was a personal producer, Sierra, I think back to the fact that when we think about estate planning, there's really several components to it, and what you all bring to the table is something very unique. Estate planning starts when you begin your working career and you start accumulating an estate, you start accumulating assets. And then at some point during your life, you're going to take those assets in retirement and begin to distribute those assets so that you've got income, but ultimately passing those assets on. But all along the way, there are issues that come up, health issues, medical issues, accidents happen, injuries happen, other things happen where estate planning services are important. And one of the things I like about what ITS does is they give you the opportunity, as Sierra said, to stay engaged. So Sierra, I guess second question I want to pose to you would be, isn't estate planning only for the rich or for business owners or for those who have a lot of assets?
So I think that estate planning is for everyone. Obviously, you're simply planning for your estate. It's kind of like saying, oh, the doctor is only for the rich or people who have a lot of money. You just have to find an affordable way to do it and what meets your needs. So a lot of people think that a trust is outside the scope, that people hear the word trust and they think of someone who's rich or has a huge estate or is protecting their business or different properties. But the matter of fact is that trusts were just too expensive to maintain before. utilizing technology and working with your financial advisor or an insurance agent in conjunction with your attorney at ITS is going to make it affordable, and you can change it without having to reinstate and repay for the entire process every time there's a small change in your life or a big change, such as a new beneficiary or selling or acquiring a large new asset.
So Sierra, I think what you're saying there, I'll let you add to this a little bit. This unique system that you have developed, you and Gary and the team there, and continue to refine, is an opportunity for a financial advisor to partner with someone like yourself in the network, have an opportunity to engage their clients without losing control of that client or having that client being introduced by an attorney to another financial advisor, but also being able for that client to manage the changes in their life. Kids being born, kids getting married, grandkids coming into the household. All of those things become a part of estate planning that they can manage inside this platform.
Yes, we're making it very inexpensive to maintain a trust. It used to be unaffordable to someone, and a lot of people just would weigh the pros and cons, and it just wasn't worth it. It was the superior way to estate plan to have a fully comprehensive, all of the documents, trust, wills, everything. But of course, you had to weigh it against what you could afford. But if you can afford the best documents to use, then of course it's, better to use that.
Absolutely. Now, many of the advisors that may be listening to this, Sierra, maybe have never really gotten involved in estate planning. And just from a general basis, a lot of them may not know the difference between a will and a trust. Can you take a few minutes and maybe define the difference between a will and a trust from the ITS perspective?
Yes, and I think this is something I have to explain on the daily. A lot of people hear a will, they think they're good, and that's all they need for estate planning. In reality, a will is directions for the court when you go to probate court. So if you die with a will or you have a will and you're incapacitated and they're trying to look at your estate, they're going to file a court case. You're going to go to probate court. It's a testamentary document, and it's going to give directions for what should be done with your estate. Whereas a will is a testamentary document, you have to file it in court. A trust is simply a contract. So you are outside of probate court, you are outside of that testamentary law, and when it is time to settle your estate, it's going to transfer outside of the probate court if it is properly funded. So what will happen is you have a contract while you're alive with yourself on you being the creator, the trustee, and the beneficiary. And then you appoint successor trustees and beneficiaries. So it's the person you appoint the person, entity, law firm that you appoint is going to be the trustee and step up. And then the beneficiary is going to be those people that you listed as the beneficiaries of your assets. So it's doing essentially the same thing, but it's private. It doesn't have to be filed in probate court, which, is all those court documents are public records. Someone can go down to the courthouse, and now with the internet, can go online and pull your will and sit there and read through your will. And so with a trust, it's keeping it as a private document outside of that probate court. So it's a seamless transfer.
Sierra, one of the famous cases I remember reading years ago as it relates to wills and trust was the story of Bing Crosby. When Bing's first wife died and that will was probated, everybody in the world knew everything there was to know about Bing Crosby. And as a result of that, Bing set up a trust. And later on, when he passed away, all of his affairs were private. You didn't have everybody and their uncle down at the courthouse trying to dig into and find out what all Bing Crosby and his family had in terms of assets and resources. And so I think the privacy issue is something for a lot of people that's valuable. And if you've ever had an opportunity, as I have, to be an executor for an estate from someone that had a will, and it's amazing the people that come out of the woodwork if they find out a family member has got money, trying to in some way separate you from that money that you would like to go, or family members would have liked to have gone to their heirs at death. And I love what you talked about with a will really expressing the wishes. But I remember when my aunt died. She had a will, and no, I'm sorry, it was my uncle. My uncle died, and my aunt was convinced that my uncle had money that he didn't have. And one of the things that she did was she challenged that will in court. And what few assets he did own, she tied those up for several years, trying to find the money that she thought he supposedly left to her that he didn't have. And by the time everything was all said and done, what few assets he had, he wanted to leave to nieces and nephews and people he cared about, ended up being gobbled up in legal expenses, and nothing ended up being passed on. So the privacy aspect to me, I think, is very, very important. Now, probate, and correct me if I'm wrong here, Sierra, probate is really the system, the legal system by which titled assets are transferred at death. Because if you're dead, you can't sign the deeds or the titles to property to transfer it. So the process of transferring that is probate, correct?
Yes.
And can you kind of give us just a real quick, maybe quick snapshot of what happens when you have a will and you go to probate?
Like the quickest way to say it is that, they're going to read your will. They're going to look at the directives that you've put in there to see what you want, your wishes, and they're going to go out. They're going to collect an inventory of all of your assets, because in a will, you likely have not listed every single thing that you own, such as bank accounts and, things that you might not think to specifically will to someone or give to someone. And so they're going to go through this probate process where they have to ledger all your assets, they have to divide them up, and then they're going to try to divide them up the way that your will states. But then again, public record, you leave more to one kid, or you don't leave something to some distant family member, or even a creditor or someone that's looking to collect something from your estate. It doesn't even have to be someone related to you. But all these people can make contestations against the will. So they're in the courtroom and they can actually file a contestation against what you've said. So the process gets drawn out. We all know how long things take in court process. So you file your probate court proceeding, and it's not as simple as it sounds, because, there are judges, there are people involved that need to go through everything, and you have an attorney involved and probably some other person's attorney who might contest the will. So it really gets drawn out over a long time. I think something very important to mention that a lot of people don't know about probate court is that when you file a case in probate court to settle your estate, all of your assets are going to get frozen. So even, it could be a simple will. You're leaving everything to your one child. You only have one child. Someone comes and contests the will, and now it's been dragged on for months or even years. And this entire time, that beneficiary is paying the attorney bills out of pocket, because that attorney's not working for free. And all of your bills, or if you have a house with a mortgage, you have a company with employees, someone has to step up and take care of those things. So it's not just the hardship of going through that probate court. You kind of have to remember that, life continues on outside of that as well. And all of your assets are frozen while the court's trying to decide what to do with them. Because if they don't, they're not protecting them.
Absolutely. My grandfather was an uncle, and I remember one of the things that he said to his kids growing up was the fact that a will might be the cheapest document from a legal perspective that you can have prepared, but it can be one of the most expensive to have to follow through on the back end of, and really cautioned against just the use of a will, but to also consider a trust. Now, we have an issue, Sierra, that happens from time to time. We just talked about what happens when someone dies with a will and they go through the probate process, but what happens when someone doesn't have a will and they go through that intestate process?
Well, that's when they're going to have an executor. They're going to try to go through the same process. They're just not going to have any directions from you at all. So your wishes are being followed even less than they were originally.
And as I understand it, in most states, they've got kind of a preset rule of thumb that they're going to follow. And the way those assets are going to be distributed may not be the way the individual that just passed away desired, but there's not a lot of latitude that I understand from the court system when it comes to dealing with someone that died without a will.
No, and each state is going to have different rules. So now you don't have a will. So you're not even 100% certain where your estate's going to be settled, who's going to come from what state, what rules they're going to follow. There's community property states and non-community property states. And so ownership could have changed in your lifetime. It's just really, really messy. It's going to change from state to state. You're not doing the job of planning for where everything's going, and you're not leaving any direction. So it really just means that it's completely up in the air. It's up to your state laws. It's up to who has an issue with it, who's stepping up, who tries to become the executor, who's working with an attorney. I mean, when you die without a will, the quick answer is who knows what's going to happen.
Sure. And Sierra, here in Arkansas where we live, we've got a lot of people that come in from out of state that have vacation homes here. In Florida,
Hmm.
where you reside, you see the same thing. A lot of people that may live in New York, New Jersey, Connecticut will have summer homes somewhere else. If they die intestate and they've got property in Arkansas or property in Florida, property in another state, do they end up with probate in all of those states?
Someone's going to have to collect those properties from all of those states, and it's likely that they could end up in probate court in each one of those states.
So this can become a very cumbersome process for an individual that dies without a will. And even with a will, if they've got multiple properties in multiple states, you could end up with multiple jurisdictions involved, correct?
Absolutely. And you see that happen a lot because people will make a will and then 20 years later they'll die and they've not listed anything in there. So not only do maybe they might have, a half written will, or they might have some document. And a lot of times you see an incomplete will, give everything to my son, and they think it's going to be easy, or even more common, oh, my wife will just get everything. But maybe, the husband or the wife has properties in another state and it's solely in their name because that's just the way it happened. And they don't know where everything is. So it gets very, very messy when you don't have a will, even messier than with a will sometimes.
Yeah, absolutely. Now, compare that to what happens when someone dies with a living trust. What happens when someone dies and they've put a trust in place with integrated trust systems and they're no longer here?
So something that's very important is we kind of talked about the importance of a living trust or trust in general and how you're going to create a contract on where your assets are going to go. What is very important, and we utilize, again, that technology aspect of it, having a virtual console allowing you to continuously fund your trust. Funding your trust just simply means listing everything within your trust. So if you have everything listed in your living trust, you're going to avoid the probate court. You are going to be in charge of, you have decided where everything is going to go. It could be as simple as, I want everything split down the middle between my two children, or leave everything to my wife first. But at least everything is going to transfer outside of court that you have listed in there. And then you are going to avoid all those issues with the contestations, people, making a claim to your estate, and it's going to transfer outside of probate court quickly and a lot more seamlessly than it would have if you had to go through that entire probate process where they're ledgering everything.
So this essentially becomes a private transaction versus a public transaction.
Yes. I mean, that's one of the most important things. You're not going to have to file this trust in the court where people can pull it from the internet, pull it from the courthouse. It allows you to do what you want without outside question.
Yeah, I know in the past working with families that have dealt with individuals that have died with a will, uh, having to go down and file that and go through the process. And then I've watched other families that have had a trust in place. And when mom and dad passed away, the successor trustee stepped in and followed the outline of the trust, distributed the assets very quickly, very efficiently, and all of the heirs got what was intended that they receive. And it was almost a seamless process. So I think there's something unique there. But one of the things that I have seen in working in this estate planning arena for a number of years is the fact that a number of individuals will have a trust, but they don't either transfer assets or assign assets to the trust. Why is this important?
So the most important thing is you have a contract governing what you're going to do with your assets. You have to list those assets in there. So they need to be identified in the trust document. It happens a lot. You see it, in classic attorney's office. People will come in, they have to go through probate court. They have some sort of trust document. Maybe their house is in it, but nothing else. But if you don't have everything listed in there, what's not taken care of by your trust is going to be pushed into probate court. And depending from state to state, there's a different limit on having a, quick settlement of your estate. But I know in Florida, I think it's $75,000 now. And, your house is going to likely push you over. You put your house in the trust, your cars might push you over, your vacation home might push you over. So then you're being put into probate court. And at that point, they could ask for the trust to be submitted as an exhibit. They could subpoena you. So it's one of those things that, yes, a trust is great, but you have to fund it. And it used to be a lot harder to fund it. You'd have to reinstate it. All you have to do, though, is list it. So this virtual funding method that we have allows the client to go in and add things to the funding ledger or the asset list. Their financial advisor can help them, and they can learn how to do it on their own or with the assistance of an attorney. Whatever computer literacy they have, wherever they're comfortable, is how we're going to get these assets into the trust.
So Sierra, if I'm hearing what you're saying and knowing from experience in working in this arena the value of a living trust, one of the questions a lot of people will ask, especially consumers talking to their financial professional, is, I hear I need a will or I hear I need a trust. One of the questions that's often asked is, do I need both? Do I need a will and a living trust? Would you like to speak to that?
Yes. So I'm a firm believer in that, don't do something halfway. You have one of these documents, if you have a living trust, you've done a pretty good job, but what does happen if you forget to assign something to the trust? You're going to end up in probate court. So why would you not, at this point, have a document that's going to function as a will? So what we do is, with all of our living trusts, we're not even charging for it. It's with the living trust. We give everyone a pour over will, so that if they ever end up in probate court, it directly says, any of my assets I forgot, pour them back into the trust, follow my trust directives. And it's as easy as, I think it's a 3 to 4 page document. You can assign guardianships in there, but most importantly, it's going to work together with the living trust so that you have a safety net if you do end up in probate court, and the safety net is going to work in conjunction and direct them to follow the living trust.
Sierra, when I used to do estate planning seminars and workshops for clients, and I did a lot in the church space years ago in the estate planning arena, one of the illustrations that I would use was I would have a box, I would have a empty glass, and I would have a pitcher of water. And I would use the box to represent the assets that were put in the trust. And I'd have a little car and a little house, and would just symbolize seeing those assets being assigned or placed into the trust. And then I had this empty glass, and then I had a small container, a little small pitcher of water. And I would say, what if there's some things, and I would pick up that little pot and I would stir it around with some colored water in it so people could see the water. And I would say, what if these things were left out either accidentally or on purpose and not put into your trust? How do we get them there when you're dead? And the analysis of being able to set the cup inside the box and then pour the contents of that pitcher into that box with the cup inside of it really helped give people a visual of what that pour over will does. And it's exactly what you said. It takes what's not in the trust, pulls it back out of probate, and pours it back into that document. Beautiful analysis in the way you put that. Now, one of the questions that sometimes will come up too is, why would I want to do an assignment rather than just do instruments of transfer?
The reason you want to do this is, one, the cost effectiveness of being able to assign assets to the trust means that you can put things as small as, people are like, oh, I don't have to worry about putting my used car or my motorcycle or my bike. You can put those things into the trust because you don't have to go and reinstate them. You don't have to weigh the cost of sitting with another attorney, drafting new documents, drafting a new asset schedule and attaching it to the trust and reinstating it. So essentially, it's a cost-effective measure, but also it's going to allow you to continuously list things and remove them and maintain control of them. So in a classic situation, you've transferred the house you own to the deed. You decide you don't need a 6-bedroom house anymore, or you just are trying to sell assets. You have to go back, retitle them to yourself so that you can sell them. So it's going to be a time-saving measure too, where you're holding those assets as a trustee yourself. They're in your name. You're in control of them. So there's no need to execute this separate instrument of transfer and complicate it and make it a more costly process.
So what you're saying, I believe, is we're not having to continually retitle assets between the trust and personal ownership by using a legal assignment.
Yes.
That's much simpler than the way I've seen a lot of folks do it in the past, where you've got to go down to the courthouse and you've got to transfer the titles of your cars and the deed of your home and all of those legal documents going through that transfer process. That can be very cumbersome in and of itself. So the ability to do legal assignment uh, just makes perfect sense to me. Now, another question we'll often hear posed by not only consumers, but financial professionals themselves is, why should my client have a power of attorney?
So, a power of attorney is just going to be a document that is stating the person or entity that you want to act on your behalf. If you're ever incapacitated, a power of attorney is just while you're alive, it ends at death. But if you're ever incapacitated and say you forgot to finish the funding process, or someone needs to pay the mortgage on your home, you're not able to write that check every month. This is going to allow someone that you trust, that you've appointed, to step up and help you when handling your financial and business transactions, and allow them to sign on your behalf on bills and anything that might need to be done before it's that time to settle your estate.
Now, are there different types of power of attorney documents?
Yes, there's going to be, the durable power of attorney. It's um, so you can do a durable power of attorney over assets, over healthcare appointments. You can limit the amount of power you give different people. You can have multiple power of attorneys. You might have someone in charge of different assets or different bank accounts, and someone in charge of your home and physical assets. So you can really customize them and make them different. We use a springing durable power of attorney, so it springs into effect when you're incapacitated. Some people use an immediate power of attorney where they have someone who's helping them anyway, so they want to put it into effect immediately. So there are numerous amounts of different kinds of customizable power of attorney documents that'll fit your needs and where you are when they are activated.
So if somebody's good at taking care of you and your healthcare needs, but they're horrible with money, I could have two different people working in different capacities using different power of attorney documents.
Absolutely.
Now, another area that is often overlooked is living will and advanced medical directives. Why does a client need those?
So again, a living will and advanced medical directives, very similar to that durable power of attorney, but this is more for your physical health. It's not. It's going to allow them to make decisions in a way that you choose. So you could give the agent, your healthcare agent, full discretion. You can direct that they have to talk to your physician that's there. You can have a physician appointed that's your primary care physician, which is a lot of people who are in assisted living or something like that, have a physician that they talk to every week. So they would be involved in the decision process. Again, very, very customizable. With our kind of system where it's held virtually, you can make a lot of changes. So as you age or your health conditions change, you can add to your advanced medical directives. But again, it's just to account for what you want in a time when you can't make decisions.
So we're talking about things like whether or not I want nutrition or pain relieving medication or life support, so on and so forth, correct?
Yeah, release of your mental health care documents. You could have someone who is your healthcare agent and you don't want them to be given all of your medical records in regards to your psychological care, or you can list things that you're allergic to. And as people start going through treatments, they learn that they're allergic or react adversely to different types of medications and things like that. So allowing you to update them is very important as well. But these are all things that someone who's even the closest person to you might not know what kind of medication you need to take every day and at what dosage, and what you can have and what you can't.
Very good. Now, Sierra, let's assume that we've got a financial advisor that's working with Vision Advisors and they've gotten signed up to be engaged with the Integrated Trust Systems platform and be able to offer the estate plan to their clients. How would a financial advisor, once they are signed up to be able to offer and refer services to you, how do they really introduce what ITS does to their clients?
So it's very easy. The basics of estate planning is all that a lot of these advisors, and we call everyone who's bringing people into the system advisors, all these advisors have to explain to their client. You're always going to have an attorney that is your network attorney, that's that person, that's your point person. So once I'm assigned an advisor, I'm their network attorney. If they ever need help explaining anything, there's a complicated situation, I'm there to help them. But essentially, all they do is schedule a time where we can all get on the phone together, or whether I have to talk to their clients, and we just start the process. People are very aware that they need these documents, whether they know about trusts, they've at least heard about wills, they've heard about the process of estate planning. And so, really, you just have to educate yourself on the very basics of what is going on in an estate plan. And you're going to have this attorney to work with you and do the implementation process and get everything done. So, as long as you can explain the importance of doing estate planning to your advisors, it's very easy. You get on a calendar, schedule that time, and get your clients in touch with your network attorney, who will be the same attorney that you're assigned from the beginning.
And so the introduction of a client to someone like yourself, um, that's done by phone, that's done by scheduling something on a calendar. What's a process once they're in the system? What's an easy way for them to connect with an attorney like you with their clients?
So, I mean, of course, we can do a phone call or a screen share. A lot of these clients come to me, they're already ready. They go, oh, I can get all the documents I need. I don't need to see another attorney. And we really make sure that any document they could need in regards to estate planning is in this virtual console that can be pulled by the advisor or them or their attorney. But we don't want them to have to go see another attorney. They hear how cost effective it is. It's only going to take an hour initially to get an hour and a half to initially to get everything set up, drafted and signed, and then the funding process is continuous. They're all on board. So most of the time we go ahead, schedule a slot to do a screen share. They can see what I'm doing. I walk them through how to go in the console themselves. A lot of times the advisors will join, even, throughout the whole process, just to give some extra notes, because you guys are the ones who really know those clients, but you don't need to. And so most of the time they're coming to me, these clients are very excited, want to get it done. They dreaded how difficult it was going to be to go to an attorney's office and physically sit there for hours and go through these documents. So essentially, I might be biased, but I think it's a very easy sale. It's something that these people need. And so once we get to the point of scheduling an appointment, they pretty much just want to get on a screen share and get the process going.
Fantastic. Now, how does a client know what estate planning documents they need?
Well, a lot of clients think they know what they need. So they'll come to us and say, I just need a will. I know I just need a will. I've heard this my whole life. Or I don't need this. I don't need that. We're going to give them all the documents. We're going to give them the living trust. We're going to give them each a pour over will, healthcare directives, any durable power of attorneys they may need, any transfer letters, transfer request letters they may need. So we're going to give them all of the documents.
And so that eliminates the question of what they need, because they're essentially going to get everything they need in one place.
Yes. And then when they ever need anything, we have clients who set up their trust, their will, and I have clients still, they'll email me, hey, can you recommend someone to draft up a durable power of attorney for me? And I go, we already did this. We've got it in here. Like, let's get it done now. I'll email it back to him. I go, look, it's even e-signed by you. You can get it notarized if you want, but here's your document. And so they're very excited because, they forget even what they have, but anything that they might need as far as planning for taking care of their mental health, their assets, it's going to be available to them.
Yeah, and the other thing I like about this platform is the fact that the planning documents can be customized based upon the needs of the client. They have a special needs child. They have a unique tax situation. The documents can be drafted based upon the appropriate code to be able to meet those specific needs.
Yes, and that's a common misconception when people hear we have a virtual platform. They think we're more along the lines of a cookie cutter document set, but these documents are not cookie cutter. They are drafted by an attorney. So just like in any attorney's office, I hate to tell you guys, they're not writing those wills from scratch every time. They take a basic document and they customize it. Just because they're doing it on Microsoft Word and we have a really nice platform that assists us and make it more cost effective, you're not sacrificing any of the customization. In fact, you're probably getting more customization because you're allowed to add extra documents yourself. You're allowed to add notes in yourself. And we are cutting out that hours of work, putting margins in a page. We made it easier on our attorneys so that the attorneys can spend the time with you actually customizing the documents for the client rather than starting from some Word document and copying and pasting everything in for hours.
Sure. Now, how does a client know what this is going to cost them?
We have that promulgated cost every time. So the advisors go, they have their code, and it is that one-time placement fee every time. And then there's the membership if they want to keep it open and keep the attorney's help, which I know the membership fee is $69 a year. And I believe that I sent you your price list. I just don't want to misspeak here on your price.
Yeah, we don't have to go into the exact numbers, but
Yeah.
it's very easy in the platform when you log in to be able to see the pricing that's set up with you as an advisor working in the system, and you'll be able to share with your clients what they're going to be paying. Now, another question I know you're going to hear from advisors is, how involved in the process can I be?
That's the beauty of it. The advisors can be as involved as they want. It can change over time. So when they're going through the data entry section, which is, the data collection, it can be as minimum as one of the client's first and last names, their email, and their phone number. Or they can go in and assist me with a whole slew of information of the beneficiaries, what the clients might want as far as notes, if they know what clients want to do with their IRAs, with where they want the money to go. So they can take it from the comfortable level of getting the client's name and providing their email to me so we can do a screen share, to filling out an entire data entry sheet. It doesn't matter, because no matter what, I'm going to go in, I'm going to redraft everything, I'm going to review everything, and I'm going to go through everything with the client so that they legally understand. So even if you don't really understand what a trustee is, you can appoint a trustee, and when it gets to that point, your attorney's going to talk to the client and explain to them what a trustee is. This is how it functions. And then the client's going to either agree or will make some changes. But either way, that attorney's there to support you. So whatever you enter and whatever you try to collect for the attorney is just going to help, and the attorney's going to review it. So it allows you to be as involved as you want.
Fantastic. Now, if they need to update or amend their documents, that's a very simple process in your platform.
Yes. And so again, that kind of actually deals with how computer literate the clients are. I have clients who are great, log in, make the changes themselves. And then sometimes they'll send me an email, hey, can you make sure that I didn't do anything wrong? Can you look to make sure this direct is right? Or, my beneficiaries are right. And if something seems wrong, I will contact them again. But most of the time, it's going to be either a client reaching out to me or the advisor, and they might say, I just want to change my beneficiary. And that's as easy as logging on and adding another beneficiary. Someone had a grandkid, we just put the name in, we hit e-sign and save, and it redrafts all the documents in that matter.
And again, I love that you bring up the fact that this is all electronic. So we have the ability, even as we're still dealing with this coronavirus pandemic here in the country, to deliver these services virtually.
Yes. And I mean, it's great because I know a lot of my clients aren't driving distance to me. They put these things off because they don't want to meet in person. It's going to be so difficult. It's really hard for someone to say, no, I don't have the time, when we can get in their house, get in the computer, go on and do these documents with them. They can make the changes from home. They can draft everything from home. So it really gets people moving on something that they needed to do. They don't want to set that appointment and come sit with us, and even for an hour. So it's really awesome to have the ability to have the reviewable and the hosting on a secure server.
Yeah, and I think you've really already answered this next question, but we'll just kind of touch on it real quickly. How does my client or an authorized person access documents? Everything's online, so essentially it's just a login, correct?
Yes, the client has a login. If they have an authorized person, they can actually even make a login for someone where they can't make edits, but they can see the documents. So say they want to show it to another attorney, to their kid, to their trustee. So it's very shareable and very easy to get in. Their advisor is going to have access to their documents to help them collect them. And of course, their attorney is always there if they need some sort of document that they might even want explaining on. Their attorney is going to be there as well.
Excellent. Well, I've saved one question for me that I want to answer on behalf of those that are watching this video that we're putting together, and that's, how do you get started? How do you, as a financial professional that are interested in adding estate planning services to your practice, you've had an opportunity to hear what Sierra and I have been talking about, and you say, hey, this is something I want to do. How do I do it? Well, it's as easy as one, two, three. You need to be appointed with Vision Advisors and be working with us as a licensed financial professional. We will then provide you with a registration link where you can join integrated trust systems. And then once you've done that and you've got your login credentials, you simply start referring clients to integrated trust systems, and they're going to have an opportunity to interact with Sierra, and there's other attorneys in the network across the country. If they choose to work with them, they could do that as well. So if you have questions related to getting started with integrated trust systems, give us a call here at Vision Advisors. Our number is 1-800-505-8489. I'm John Terry. You can also ask to speak to Melissa McNana or Gary Raggio, and we'll be happy to tell you how you can get registered with ITS and begin offering these services to your clients today.